This is Barry Zalma, speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk more about why lies on an application for insurance resulted in insurance never existing, and why rescission results in a policy being void from its inception, even when the arson for profit turns out to be a violent crime. Imperial Casualty and Lloyd's Underwriters retained me in the 1980s to advise concerning the fire claim presented by Levon Sogomonian and his wife as a result of a major arson fire and explosion that destroyed their home. The investigation took more than a year, multiple days of examination under oath, death threats to the claims investigator, and a bomb threat at my office that eventually established the leading case in California concerning rescission of insurance, now called Imperial Casualty and Indemnity Company versus Levon and Elichka Sogomonian, a February 4, 1988 decision of the California Court of Appeal, where Levon and Elichka appealed from a summary judgment entered in favor of the plaintiff Imperial Casualty Insurance Company on both Imperial's complaint and defendants' cross-complaint. On July 14, 1982, Imperial issued a homeowner's policy to the defendants, which provided casualty and fire insurance protection for their home. On or about October 9, 1982, defendant's home was destroyed by a fire and explosion. A second fire on October 10, 1982, was a second arson fire that destroyed what had not been destroyed by the first fire. Following an investigation, Imperial concluded that certain misrepresentations and a number of omissions had been made by the defendants in their application for the policy, which they had submitted to Imperial on June 7, 1982. Imperial sued, seeking rescission of the policy ab initio, or from its inception, together with the judgment of the court so declaring, and repayment with interest of advance payments against the then anticipated fire insurance proceeds which Imperial made to the defendants on or about November 18, 1982. In its motion for summary judgment, Imperial produced evidence that the defendants, in responding to questions in the policy application, one specifically denied for the immediately preceding 3 years any loss history and any policy cancellations or renewal refusals, and two, refused to include the following facts. 1. That in February 1980, within 3 years of their application, defendants suffered landslide damages to their property, which resulted in a legal action for $500,000 in damages filed against them by a downhill neighbor. This claim was submitted by the defendants to their then insurance carrier, Equitable General Insurance Company. 2. That in early 1981, the defendants suffered an uninsured loss by theft of precious stones exceeding $100,000 in value. 3. That on December 12, 1981, Underwriters Insurance Company had canceled a homeowner's policy which had previously issued on the same property involved in these fires. 4. That on March 29, 1982, the defendants had presented a water damage claim to Blue Ridge Insurance Company with respect to the same property. And in fact, their check was delivered on the same day they signed the application to Imperial. 5. That on April 5, 1982, over 2 months prior to the submission of the application to Imperial, the defendants had been notified by Blue Ridge Insurance Company of the non-renewal of the homeowner's insurance policy which that company had theretofore issued. Subsequently, on July 19, 1982, just a few days after the issuance of Imperial's policy, defendants were informed that the reason for such non-renewal was the substandard property maintenance by the defendants of the same property, and defendants did not ever provide such information to Imperial. 6. That at the time of the application, there was pending a lawsuit with the Equitable Life Assurance Society wherein the company sought to rescind a health policy on the grounds that the defendants had made material misrepresentations and omissions in the application for that policy, and 7, that at the time the application was made to Imperial, defendants had a second mortgage on their property with Alliance Bank. The existence of a first mortgage with American Savings and Loan Association had been disclosed. However, the total owed on the home was approximately $425,000, of which nearly one half, or $200,000, was secured by an undisclosed second trust deed. Imperial offered the deposition testimony of its former underwriter, who was responsible for making the decision to issue the subject policy. She testified that she relied on the defendant's application, and had she known the true facts, she would not have approved the issuance of the policy. In their brief, the defendants effectively conceded that of the established material issues of fact claimed by Imperial, they only really disputed 3 and did not dispute the remaining. Given the state of this record and defendants' concessions in their brief, the Court of Appeal was compelled to the conclusion that no factual dispute existed with respect to the facts of defendants' concealment of certain information requested by Imperial. Moreover, there was no factual dispute that Imperial issued the policy in reliance on the truth of the statements made by the defendants, and that Imperial's underwriter had stated that had Imperial known the actual facts, which only came to light during the post-fire investigation, it would not have issued the policy. The Court of Appeal concluded that the application submitted by the defendants to the information sought by Imperial and denied to it by the false negative answers and omissions of defendants were material to Imperial's decision to provide insurance coverage. That conclusion is the only one that reasonably can be drawn from the undisputed evidence presented. Sogomonian attempted to get around the rescission by claiming that the insurance companies violated California Insurance Code Section 790.03, H, the bad faith statute. However, the court concluded that since a contract is extinguished by rescission, the consequences of rescission is not only the termination of further liability, but also the restoration of the parties to their former positions by requiring each to return whatever consideration has been received. Since the summary judgment order did not provide a complete restitution to Imperial and Lloyd's, the judgment was reversed with directions to the trial court to make and enter a new order granting summary adjudication of issues, which is consistent with the court's opinion. A trial was held thereafter, and I personally testified as a fact and expert witness, only to have Mr. Sogomonian threaten my life as I entered the courtroom to testify. Judgment was had in favor of Imperial and Lloyd's, and they recovered all advance payments, their attorney's fees, and their investigation fees. In my opinion, this case is most important because it established the law of the state of California with regard to rescission of insurance. Although there was evidence that the fire was created on behalf of Mr. Sogomonian, no criminal charges were brought, and Sogomonian continued to attempt to gain from the fire by suing the investigator. It took 15 years of work to resolve all of the litigation brought by Mr. Sogomonian and his family, and after he lost all of the actions against Imperial, Lloyd's, and my investigator, he went on to litigate with others on various other schemes. Contrary to his hopes, I survived and am now 81 years old and still working. If you want the full details of this case, see my book, quote, Arson for Terrorism and Profit, close quote, a fictionalized novel about this arson for profit scheme, which is available as both a Kindle book and a paperback from Amazon.com. This video was adapted from my blog, Alma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. At that URL, you can subscribe to the blog and you'll receive notice of all blog postings, usually 5, sometimes 6 a week. And you can also gain access to all more than 4,600 blog postings. You can also subscribe to the videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the thumbs up button on rumble.com and the like button on YouTube. If you wish further detail about insurance, insurance law, insurance coverage, and insurance fraud, please consider for a small fee subscribing to my Locals community and/or my Substack publications. Thank you for your attention.